How you guys doing today? It's Anthony Ganji. Welcome to another episode of Tier Talk. Saturday morning. Good morning, everyone. So today we are going to be talking a little bit about exhaustive interrogation framework for the David case, D4VD. This is a very complicated case, and a lot of people are asking, why hasn't he been charged yet? And since I think I'm pretty much up to date with most of the updates that are coming our way, I figure we can explore the process of interview and interrogations. I'm hoping to have Joe Pangaro come on sometime next week, if we still need something to kind of revisit this. But I do have some knowledge in this because working in corrections, inmates sometimes do foolish things, and they do get interviewed and they do get interrogated, and we have to go ahead and ensure that we get the information we need to run a safe and secured facility. I would say most people in corrections, including our investigators, are very excellent at this type of work because it's extremely frequent. It's pretty much our day-to-day. So with that said, you got to remember in this case here, you have someone that has contact with a minor, but we still really haven't understood how deep that contact is, because that's going to be important. And then you have a body of that minor that was caught in a vehicle that was registered to him. So with that said, definitely a reason for David to get a lawyer. Let's start right off the bat, because I think there's enough evidence there to showcase that he was in the proximity of a minor. But we still don't know the depths of that relationship. And I still think that is what LAPD is probably exploring at this point. The DM messages, all that stuff, talking to the neighbors. I know there was a recent video out, I think it was by Ashley Bansfield, that talked about, maybe News Nation, one of the two, but she talked to one of the people from TMZ, and they talked about how Dave's friends or neighbors all knew that they were a couple, but as one of the other videos I'm following on this, podcast I'm following on this, it's like, but they didn't have any public display of affection, so there was really nothing that showcased they were a couple, just the fact that I guess they were constantly together, and that's really not enough in court. Plus, she is a runaway, so maybe there could be, if they prove there's a connection, did you do the right thing when you had this child here? Did you call the local PD? I mean, she is underage. Again, it's funny because everybody's come up with all these fake IDs that she had. So will someone say that we didn't know her age? And I don't think that will play well for David if he tries to go that route. I think there's probably enough evidence to showcase that he knew her age. And I tell you something, guys, these people, when they think they're privately messaging someone, they swear to God that those messages are only between them and the person. And trust and believe, any message on a server, any message on a phone, whatever, they all can get picked up again. Even if you delete them, they will show up, and it will expose what type of relationship you had with that individual, including nicknames. What were the nicknames you guys called each other? That would be a great question to ask. But I think, as I said, you're going to want to go and establish the relationship, the depths of that relationship, and then ultimately have it lead its way down to her body being found in his car. Now, the relationship details matter because could be motive behind that. She is underage. So you have to get someone to admit that they knew they were a couple, including David. If he was a couple, he's going to have to admit that. That's going to be tough for him to admit. And it's also something that's not going to be dismissed, because that would be the first thing I'm assuming law enforcement is going to chase, is the connection. I think they're going to chase after that connection first. And then after that, see where the road opens up. But you have to establish that connection, because that connection is central to, in my mind, my opinion, to any motive that could have led to her demise, whether it's a breakup, some level of control for doing the illegal stuff. So even though he may have thought he was in control, she did have some leverage and control on that because of her age. We talked about a theory yesterday with other people knowing that they could be a couple. So again, her age could be a problem there. So even if it wasn't Dave who actually did it, but maybe somebody else, what would be the reason why? Because she was underage. Could be. So the age is essential, and that connection to her is essential. And again, all because they're next to each other doesn't mean that they were sexual in nature. I mean, a lot of us are making the assumption, so that's what the detectives have to prove. And I think it's extremely hard, especially when he's going to probably have some good lawyers. So, I mean, even if he wasn't involved, and this just happens to be some crazy ass coincidence, which would be some crazy ass coincidence, he's going to have good lawyers. And I want to kind of explain a little bit of what goes into the process of interviewing someone, and then obviously making the allegations or the accusation towards that person, and then maybe building enough to get charges out there. And it's really not easy. It's not. And I actually understand why this could be taking more time than a lot of people would expect. So first thing I want to talk about, and again, we're going to be talking about the interrogation framework for the David case. I'm going to kind of break down how I believe, and again, it's just my thoughts, how this could fold out. So I just want to put some notes up front. You always, as an interviewer and interrogator, you always have to respect the legal safeguards. So the person has to be Miranda'd. They have to be offered the right to legal counsel, etc. Now, if the person invokes counsel or his rights to be silent, then investigators must stop or follow proper legal protocol. So that could also be something that takes its time, because even though he was cooperative, we don't know, what does that mean? Was he cooperative because he just showed up? Was he cooperative because he was really giving out information because he felt guilty? I mean, we really don't know. But if he was cooperative to that level where he was speaking about everything that happened, he would have been a person of interest, or he would have been maybe he would have been charged depending on the circumstances, but we don't have that yet. So I think, to be honest with you, there may be some legal concerns right now that's stopping them from moving forward. And then you have to avoid any form of physical or psychological coercion, promises of leniency, and you're also not authorized to give threats or deception that would render statements inadmissible or abusive. And that's because later on, if it ever does go to trial, these interviews are shown, and it's actually evidence. And what they'll look for is if you're the investigator, the person interviewing David, they'll look to see if you offered him anything that would make him want to say he was guilty. Did you threaten him? I mean, to the point where he felt he had to admit guilt. Were you physically violent towards him? I mean, they're going to look for anything to skew the effort to get a proper admission. And then the goal here is to obtain reliable, voluntary information that stands up to scrutiny, not a forced admission. So anybody that's going in to interview and then eventually possibly interrogate, if you start pushing towards that admission, you have to make sure that the whole thing you've done from beginning to end can be seen as a voluntary admission. Because if I was the lawyer on the defense side, that's one of my areas I am going to try to attack as much as I can. I may not even focus at first of whether he did it or not, even though it's going to be important evidence, whatnot. I want to check out that admission first. I want to see what happened on that interview. So I want to talk about, I broke this down to phases. So the first phase, I call it kind of phase 0, because you're not really going to have any direct interaction at that point. It's going to be the preparation. So this is before you go into the room. And this is another reason why it could take a lot of time, because we're still getting a lot of evidence. We're still getting a lot of witness testimony. So there may not be enough to move forward. So when they first talked to David, to be honest with you, he's probably just a witness in their mind at first. Let's treat him as a witness. Obviously, we know he has a connection to her. So let's be very careful of what we run with right now, because we want to try to get this person to be as open as possible. So at this point here, let's just treat him as a witness. Let's just see what information he's willing to give So then we could start opening up this story. And then when all roads lead back to David, then be a little bit more pressure. But right now, sometimes it's good to have someone be open first, without the pressure of feeling that they're being interrogated. So, hey, tell me what happened. How do you know her? You're not putting pressure. Do you know her? You're not putting pressure. So the person feels open to draw from anywhere to create a narrative that they may think they have control of. And then later on, when you decide to go ahead and apply the pressure, well, now I got some evidence. I got some ways to go ahead and start pointing the finger your way. So at this point, this is when you start doing that and you start going from interview to kind of like interrogation, this is where you start to expect the person to close up. This is where you start to get the obstacles. And you really got to make sure that when you cross into that threshold, that you have everything prepared when that time comes. So most of the time you will see somebody interviewed first, and then depending on what you get from them, if there's not enough there, I'm not going to try. There's nothing there yet. I mean, we know the person was found in their car, but we can't directly connect them to killing her. And then we also may know that, maybe he does have some contact with this minor, but we don't know the extent of that contact. So a lawyer is going to rip that apart. Are you going to charge him or not? No, then we're free to go. So there's a lot that goes in to this even before you interact with the individual, because you could assume that any possible witness, especially the person that was the last person with them, maybe is going to know a lot. So you still want to have some evidence, but if it's circumstantial at best, you're not really ready to cross into accusing the individual because you have nothing you can lean on. And when you have good lawyers, they'll rip you apart. If the guy's represented by a good lawyer, they'll rip you apart. What are you going on? What's happening here? What are you doing? You're not prepared at this point here. Either charge him or leave him. We're done answering questions. Because the funny thing is, too, I know when it comes to interview and interrogation, when it crosses into the interrogation side, and I guess that's the moment you start making the allegations, if you don't have your facts straight, one, the person that you're trying to accuse can definitely still control the narrative, but there's no pressure. And you're just throwing stuff out there. Because once you make the allegation, you're not really you're working with the evidence now to get that person to tell you what they've done, as opposed to getting that person to kind of make up the stories as to what that evidence is. That's why you really got to have an understanding of that evidence. And guys, you understand that is a different mindset, right? If I'm the interrogator, I'm leaning on the evidence so the evidence can tell me a story. But when I'm just kind of interviewing, trying to figure it out, I'm going to try to talk to some individuals to see, what their side of the story is, give them a chance to give their narrative. But eventually when the evidence starts turning a different way, the evidence is what I'll be leaning on. And then that's what starts pushing, any interview or interrogator to start crossing into making the allegation. And again, it's tough because when you start making that allegation, even if you guys were working together, hey, let's work on finding out what happened to Celeste. We knew you knew her. You're trying to do the right thing. So you build a partnership, and that even, by the way, guys, usually that partnership, you're sitting right next to the individual, you're working together. But once the evidence starts saying stuff otherwise, and that there's going to be a point where you're going to have to cross into making that allegation, that rapport is gone. So you're very careful of when you make that allegation. You got to make sure you're ready, because now the person wanting to help you, they're going to stop. And now it becomes you're going against me. I'm here helping you. So it's not something that you just go in blindly. So there's usually an initial evidence inventory. So it's a list of every piece of objective info that the investigator is going to have. That's timestamps, phone pings, bank records, CCTV stills, witness statements, everything. And you're going to note reliability and how you'll verify it. So again, it's kind of like that's what's going to lead your script. Then you got your interview objectives. What am I planning on doing if I bring this person in, this witness here? Because maybe at that point, they're not a suspect. They're maybe a person of interest, but I don't know yet. This was the person that last spoke to her. So what's my plan with this person? What do I have? What do I need to know? So again, you're going to interview the interview objectives. You're going to rank what you must establish. For example, identity, contact, timeline, presence at scene, actions after event. Those are extremely important. So guys, timeline, presence at scene, actions after the event, your contact with the individual. I mean, these are things that you need to find out. Now, granted, and that's what keeps them concrete and verifiable. Now, granted, guys, if a lot of that stuff that I'm trying to find out could be criminal in itself, look at all the things that they're going to protect. David may have a reason to protect timeline, contact, all those things. Because again, there's a minor at the center of this story. So, it's going to open up to what was your dealings with this minor? Was it a sexual relationship? So he could have many reasons to be very protective, even if he wasn't directly involved in her killing, or we don't know if it's killing. Sorry. Even if he wasn't directly involved in her death, he still may feel the want to protect the fact that he knew her, the fact that even if he admits he knew her, the depths of that relationship. So they're going to have to layer that, because again, that relationship, I think is truly essential. Sorry, I got disconnected there for a second. So I've talked to some investigators, including Joe Pangaro, and he says they also, before they go in, they like to create a question tree. It's a branching list of questions by phase. So opening questions, clarifying questions, and then closed questions. And that includes follow-ups for denials versus admissions. So what they'll do is they'll try to have some questions to create a good narrative, areas where they need more information on. And then if worse comes to worse, clarification. But they also go ahead and, because they've done so much of this type of work, they're very familiar with human behavior. They may even, they'll prepare one road as if there's omissions in these areas, but then they'll prepare another road for questions that could be where the person's more protective and maybe outright deny. So they're going to go ahead and branch out possible areas to cover and basically give them fallback plans. So again, if the person outright denies this, what's the evidence we can utilize to start pressuring that individual to start letting us know, start pulling the truth from them. And that's when, okay, so tell me a little bit more about this evidence. How do we get it? I really got to stay focused here, because if I'm going to utilize this to challenge their narrative or to challenge their denial, I really got to be on point. And again, it's open. It's then to clarify, and then ultimately it's to close it down. And again, in the process, that branches to help get questions that help flow well. If there are omissions, let's keep it going. Let's keep it going if it's working. But we do expect some denials in areas that they have reason to be protective of. Again, timeline, you may find denials there. Contact, in this case, you may find denials in just a few areas that are sensitive to anything that could put him in some legal binds. And by the way, sometimes when people become sensitive or protective, doesn't mean they're always denying it. It just means that it's a legal issue, and they want to be very careful on how they word it before it gets tossed around a bit. And believe it or not, that's extremely important. That's why it's always good, even for innocent people, to get lawyers, because sometimes when you're being interviewed and interrogated, I mean, these guys are experienced people who know how to ask questions, and sometimes they may get you to admit to something that you haven't done. And I've done a video on that with Joe, how Joe was responsible for a false admission. And the person actually started believing that they did it. And that's a real phenomenon. So with that said, it's just preparing kind of like something that you could work on that gives you direction, just in case this person tries to pull the narrative in a different direction. But all because someone's protective of someone, let's just get this out. It doesn't mean they're guilty. They could be protective of something that they may not want to release because there's greater consequences. So maybe, hypothetically, sure, he could be guilty of having contact with her because there may be enough there to show that there's proximity, but the next step is kind of push something sexual. So now if I was being interviewed, yeah, maybe I didn't do the right thing. Maybe she was a young girl that I thought I could help running away from a home. So maybe she was like a friend to me, but it doesn't look right. But doesn't mean that can't be the case. Maybe they were friends. Maybe they were close. Sure, it doesn't say anything good for David, but that could be the case. But David may be weird or maybe hesitant to admit that because he knows that's going to be hard now at that point to say that they weren't having sex because the public would start believing, oh, come on, a guy that's 17 up to 19 or 20 messing with a girl that's 11 up to 14. Of course it was sexual. Why else would he be around her? So that perspective can make him hesitant because he knows that if I open up the door and say that I did have contact with her, the world's going to think I'm having sex with her, and I wasn't having sex with her. And again, that's a strong hypothetical. But it could be a reason why he protects it because at the end of the day, the contact will then get judged by public opinion. So it becomes what's the perspective that comes from that after I open the door. So it does make sense for someone to be protective of that. And I think the investigators would know that. So the investigators, if they can't prove at this point that there's sexual contact, their number one objective would be, let's at least prove that there's a connection with them. We can explore the relationship in a bit later. But let's just see if I can get him to admit that he was with her now or knew her within proximity. And now, even when he does admit it, detectives will know, well, there's many reasons why he may be a little hesitant to admit that. It may not be because he's having sex with her. Maybe because he knows how people will view him. So these investigators pretty much know human behavior. They know that anytime someone is protective of information, I didn't say denying because that crosses into lying, but when they're protective of information, there could be many reasons why they don't want to release that. It doesn't always necessarily mean that they're committing to a criminal act, but it could be more about vanity or public appearance, especially when dealing with someone that's high profile. There's just so many ways people could skew that connection. Then you got the legal check. You're going to confirm rights were given, ensure interviewing officers know the limits. So Miranda, counsels, you want to make sure that's out before you even touch on any interview. That's part of the due process. And then you got team roles. If they decide to have partnered, you always should have more than one experienced investigator in there because one person will probably ask the questions, but there's got to be someone that really watches that individual, how they react, how they answer, kind of focused on their body language. And it's tough when you're one person trying to do all that. Even though I've seen that, it's tough. It's tough. You really need a second person to really observe their reactions to each question because one person is trying to figure out what questions they need to go on. So they're really focused mentally on, maybe I should try this or try that, where the other person could be focused on how that person's reacting to the questions. So who documents, who leads, who watches body language, records the session, because that's another thing. If you're some notes. I mean, it's hard for me now to take my notes at the end of each question and then watch how you're reacting. So I do need another set of eyes. And then don't forget, you also may have someone watching the interviews from a distance. So it may not always be that the person's in the same room with the detective. Sometimes it could be. I'm talking about the investigator. It may not be that there's two investigators in the same room. One investigator could also be watching from an eye in the sky in another room. And then the risk and ethics. So stop if signs of coercion, medical distress, intoxication, or vulnerability are present, and get counsel, medical if needed, whenever is required. And why this matters, preparation lets you present facts in a controlled order and prevents improvisation that leads to coercive tactics. So now, let's make contact. We're going to do phase 1, opening and rapport. It's going to be a very soft entry. I got to get the person's baseline because I got to know how this person reacts to certain things. I can't pass judgment without knowing who this person is because how they react to something could be their norm. So I have to look at who they are, how they answer questions, and I got to develop an understanding of their patterns so I can recognize things that are out of the ordinary. I mean, I could have a guy that sits like this all the time, and that doesn't mean he's resistant. That means that's just how he is. But if I have a baseline, I'll know that. And then if let's say if the guy doesn't do that all the time and I ask him a question, he goes like this. Oh, that's unique. That's the first time he did that. That's a question he may not have liked. So again, a baseline gives you a pattern. It allows the person to be comfortable to some extent. It's for rapport building. And basically, at first, it highlights a partnership. We're in this together, right? We're trying to find out what happened to this young girl. So at this point here, we're partners. And that's good because it gets people to lower their defenses, and you get to find out who they really are. And then that baseline is what you will compare to how the individual acts later on when they're under pressure. So the first thing I got is opening a rapport and soft entry. Okay, so remember, the goal here is to reduce defensiveness and determine baseline credibility, because you got to realize someone's coming into this first time. They probably think they're going to be being accused. So you got to try to build a rapport with them. And again, I say rapport because it's temporary technically, but you got to build some level of credibility with them as well so they can trust you. And then that gives them a chance to be open and less resistant. So what are the tactics? And remember, we're going to stay within ethical tactics. So you want to introduce yourself, your role, confirm that their rights are understood, and then record consent to proceed. That's extremely important. That's definitely part of the due process, because any one of those areas could be attacked later in court if that's not fully explained. So again, this is who I am. I'm the assigned investigator for this case here, blah, blah, blah. Have you read your rights? You understand your rights? Okay, let's just get you to sign something so we can move forward with this interview. And again, at this point, everything's voluntary. I mean, they can even have a lawyer present here. It really is, but everything's voluntary. They're not being pressured. So you want to start with a neutral, low-risk question. Hey, so what's your name? David. Oh, yeah. Familiar with your music. You also go by another name, D4VD. Okay. Maybe ask them where they live, how long in town. These let you observe baseline speech, micro pauses, and typical answer length. And that's good. It's funny doing this show. There are some people you interview who are very short with their answers, and you got to wind up coming up with 30 questions for a 10-minute show. And then there are some people that are very long with their answers, and you can probably do a long an-hour show with just 3 questions. Joe Pangaro is someone that's very comfortable in his expertise, and he tends to have longer answers. And Denise Schoenwald tends to have shorter answers. So for Denise, I got to have more questions. For Joe, less, even though we've done a lot. Some more questions. It depends. But Joe fills up the air. Sometimes you maybe see investigators ask, hey, you watch sports, or something that you may feel is off topic. Hey, I see you're into video games. My kids are into video games. You play Fortnite, or whatever it is, because these are public record. I mean, these are things that it's openly out there. So with that said, you're building a comfortability within their realm, and then you're just trying to get an understanding of how they answer their patterns. Because I don't really know this guy. So I got to figure out as best as I can who this person is and how they react to things in a very short amount of time. Then you want to use active listening. So short acknowledgments, repeat back key phrases to show you're tracking, not accusing. And that's part of the rapport building. And then you want to use open questions, because remember, guys, there's no pressure at this point. So it's if I see somebody and I first start to interview them, I may say, hey, so what happened? What's going on here? What happened? Tell me, what happened? Keep it open. But when you start to hit pressure, the what happens opened. It's an open question. You could draw from anywhere. There's no pressure here. But if I turn around and when I start to have evidence, I may come back to this person again later on, and this person knows I've interviewed other people. I've been doing this for quite some time. I got a lot of evidence here. He doesn't know what I have. So now I may not say what happened. I may say, hey, tell me your side of the story. Can you tell me your side of the story again? And now for David, it's like, wow, what else do you know? Because you said your side. That means there's another side that my story is going to be compared against. And then that starts the road to pressure. So again, use open questions. Tell me about how you first met, in this case here, Celeste. Avoid rapid, fiery, accusatory questions at the outset. So again, the key here would be, as I mentioned, to see if you can establish some level of a connection. I didn't say relationship at first, just a connection. And there's enough evidence to possibly showcase that there's a connection, at least at a surface level. So I need to get something here to confirm that connection. And I'm gonna try my best at the initial level to make sure that he knows it's safe to some extent right now to admit that there's a connection. I'm not asking about any deep relationship at this point. Just how do you know her? You know, and you have in a public platform, I'm sure there's a chance that you may not know. I don't know yet. You got to tell me. But maybe she's someone that she frequents your, you know, what you're doing a little bit more. So through frequency, you know who she is. That still doesn't mean that, you know, there's a sexual relationship there, a sexual component there. So I want to tell you what to watch for when it comes to baseline cues. Man, what to watch for baseline cues. So typical speed of replies, eye contact, voice volume. This gives you something to compare to later when stress or deception increases. That's why it's good to always have that second person there, because one person is focusing on the questions and how they're being answered, because that's a whole nother level of expertise. Then you got one person also focusing on their pattern of speech, how they move, where they're looking at certain questions. And why this is safe, useful. Rapport reduces immediate defensiveness and makes later contradictions more meaningful. As I mentioned that, if you establish the baseline, you know who this person is, and then later I can compare that with when they're being pressured. Well, that's unique. He doesn't do that. That's the first time that he moved back like this. Or maybe when you gave him something to drink, he put the drink right in front of himself as a blocker between you and him. You know, it's all subconscious, but maybe like I'm drinking and, hey, yeah, I love playing Fortnite. I'll tell you something. I've been playing that game, and there's the drink off to the side, you know. But then we say, hey, have you ever DM'd Celeste? Have I ever DM'd Celeste? Right in front. Or have you ever DM'd Celeste? He wasn't doing that before. He was answering questions pretty quickly. You know, and sometimes funny too when you ask people questions and there's this if you have someone that you're dealing with that could be hard of hearing, sometimes when they reiterate a question, they reiterate maybe the part they felt they didn't hear. So it's not the whole question, it's maybe a piece of it. But when you ask someone that may be being deceptive, sometimes they may repeat the question as if they didn't hear it, so they could buy time and seeing how they want to answer it. And that's another thing too. Like if I'm asking questions and you're answering pretty quickly, and all of a sudden I ask a question, it's the first time you repeat the whole question. Did you ask if I know Celeste? Yeah, you haven't done that before. That's the first time you did it. So now that could be a pause for you to try to figure out how you want to answer that question. And again, you only know that if you understand the baseline of this individual. So again, this is more on the interview side. You're trying to build rapport. And again, you know, if you're both trying to figure out what happened to Celeste, you're being cooperative with the individual. And it's unique because sometimes how you sit next to that person matters. I've seen it where they set up the table where if we're working in partnership at the very beginning, I may be kind of slightly next to you or off to the corner. But when it starts crossing to the point where I'm going to have to start making the allegations, I'm going to start have to pushing because I think there's something here, then you may move to the front of the individual. So I always think of it like working on a science project at first, or tutoring. You're kind of next to the individual, maybe like kind of cornered off. But then eventually it goes into a game of chess where you're sitting directly in front of the individual, preparing for that face-to-face confrontation. So the next part I got for phase 2 is factual information. And that's where you're gathering. So you're going to start moving from open questions to now you're going to peel some layers back and try to get stuff that's a little bit more specific. And this is where you may start seeing a bit of some resistance. And again, we don't know if resistance is, we don't know if the person's lying. There could be many reasons why someone's resistant outside of breaking the law. Denials, a bunch of things. And this is important now because now you're leaning on the evidence. So at one point, the person you are talking to is able to create the narrative freely. But then eventually, the evidence will start creating the narrative. And then that's when the person starts to feel the pressure. But this is where you really have to be on point. And the goal here is to collect the subject's on-coach narrative in their own words. So you're going to ask one open question at a time. You know, let's say, tell me from the beginning what happened on such and such date. Very open. You know, there's no pressure here. I'm not pushing any evidence against what you're saying or to lead into the narrative that you're going to create. So it's an easy question to start off with. Let them speak uninterrupted for a set period, maybe 5 or 10 minutes. Let them go uninterrupted. Then after their narrative, ask targeted clarifiers, dates, locations, names, exact wording. You know, so what time did you arrive? Okay, makes sense. Who else was there? Okay, you said that. Okay, good. And that was it? Okay. And what did you say next? Okay, good. So very open questions that align with their narrative. And then again, I say it's use a free narrative, kind of like it creates the details that you need. And that free narrative first, you use the free narrative first and then ask for specifics, as I mentioned. So basically, you'll start off with, as I mentioned, open questions, something that they can kind of pull from. There's no pressure here. And then you hold them to specifics of, you know, their narrative, you know, because now you got to hold them to something. And then now that part of that open world will eventually be used when you have the evidence, because the evidence doesn't really go against the generality. It goes against the specifics. One thing I learned in corrections is that people lie in generality. You know, I'm in fear of gang members, so I need protective custody. Oh, which gang? Who threatened you? When were you threatened? Where were you threatened? How were you threatened? You know, you got to hold people to specifics because people do lie in generalities to control the narrative. So again, you let them feel open with telling their narrative, and then you go back and try to drain some specifics that you'll eventually use the evidence to help, if needed, apply pressure. Then you document everything: audio, video, text. Ask the subject to repeat or write key parts if they begin to omit things. So again, that comes when you pull them from the specifics. And then why it works is spontaneously. It's basically the spontaneously offer of details, and they're more reliable than answers shaped by interrogator prompts. This is actually holds a lot of weight in court, because if you get an open narrative at the beginning that admits to something, and then later on, you know, let's say I'm playing that out, but you said this, you said this, you said this, and later on what they said during that open narrative, if it gets a bit challenged and the person starts to pull back on their story and they start to adjust, I can now pull back to that open narrative when you weren't pressured, and that's when you said it. So you can't say that you said that when that was disclosed when we were pressuring you. That's not fair. You said that first, and that's what led to this dialogue later on, because what you're saying doesn't match the evidence. So that's very important, that you do establish as much specifics as you can, because when you go to challenge and they go to pull back, you know, a lawyer may come in and say, well, you pressured him to say that. What are you talking about? Watch the beginning of the interview. I'm only going by what he said. He said that at the beginning. He's only feeling a certain way now because the evidence is saying so. He's shifting his story, or she's shifting his story. So that very beginning matters. Then you got to recognize, now this is phase 3, you want to recognize resistance types and lawful responses. So goal is to identify how the subject resists and responds in ways that preserve voluntariness, or to be, that they're voluntary, that they're voluntarily giving you the statement. Remember, guys, my words sometimes. And move the interview forward. So this matters. This is key. So again, you want to identify how the subject resists and then responds in ways that preserve them being voluntary. They're voluntarily giving you the responses, and move the interview forward. So common resistant types and ethical response templates. So you are going to have people that provide flat denials. I didn't do it. The response, stay factual and calm. You say you didn't. Well, we collected A, B, and C. Help me understand how those facts fit your statement. Ask for explanations. Don't attack. So let's say they're talking and, the body of Celeste was found in your vehicle, that's registered to you. Were you involved somehow with her death? No, I didn't do it. Okay, then you got to walk me through this, man. Got to really walk me through this, because she was found in your car. So you got to tell me that, I know she's been in your car, but tell me how you weren't involved in this. Then you want to minimize or downplay. So if the person says something like it was nothing, she was fine, you can ask for specifics and quantification. When you say a little, can you show me the exact message or payment? Press for verifiable detail. When you want to get somebody to admit to something that they've never done before, that they've never admitted to before, something that they know they can get in trouble with, and investigators are allowed to do this, they can minimize certain verbiage. They may not say murder, because murder comes with a consequence. So they'll say accident, just to get the person there, just to get the connection. May not be sexual contact. I'm not going to go out and say, hey, you had sex with her, but I may say, did you hold her hand a little bit? Something that they feel comfortable admitting to, so you can open up the door to something that can lead to the bigger admission later on. So you are allowed to minimize things, because if you quickly go hard and state, you murdered her or you had sex with her, people are going to go, whoa, because they're more concerned about the consequences. So you have to try to minimize that by using verbiage that they feel more comfortable relaying. And consequences doesn't have to even be criminal. Some guys are used to that, going back and forth in the system. Sometimes it's about reputation, how they're seen. Consequences can be very subjective. So another thing about the baseline is you start to understand who that person is, and you start to understand how to work within their flow a little bit. Because again, consequences really subjective based on how the person views those consequences. Some people really don't mind going back to jail or prison, to be honest with you. But a lot of people don't want to be called a predator. I'll tell you that right now. So again, you minimize or downplay, and you're perfectly, you're allowed to do that. That's to get someone to admit that maybe there's a connection there. And then we can figure that out later. But let's just place you there. Let's just figure it out. So again, I didn't say you murdered her, so the question would be more of, hey, how did this accident occur? Do you think you know? Or, hey, I'm not going to, hey, you right off the bat, hey, you knew Celeste? Yeah, so you were having sex with her? I'm not going to say that. But as you start building a connection, you may say, was there a chance? There are people even saying that you may have held hands. Is that true? Now, by the way, it's not that you can outright. So when you're investigating something, you could say stuff to help prompt what you need. And I'm not going to say that's an outright lie, because maybe I don't have any sources that said that they were holding hands. But a good lawyer usually catches on that and usually says, prove that was said. Don't answer anything yet. Prove that was said. So then maybe the investigator then will change questions. So a good lawyer will probably push hearsay. I don't want to hear that. So push that out. Nope, done. Don't answer that. Don't answer that. So that's makes it a little bit more difficult, but makes sense if you're looking at it from both sides. So then you have the evasion and deflection. So the person may change subject or ask questions back. That's another thing for stalling of time. I'll ask you a question and you go ahead and ask me a question. And It's like, no. The person in control is the one that's asking the questions. And then, as I said, there could be pauses when the person was used to answering things quicker. So response, you bring them back with gentle redirect. I'll answer that. But first, I need your help with this. Where were you at 3:30? And you keep the controlled pacing. So I ask a question, and then maybe you ask a question back for me to answer. Not even for clarity of the question, but for me to answer. I may say, you know what, I'll get right back to you. But hey, real quick, let's go back to that other incident. When was the last time you were in that Tesla? Anger. Then there's another sign for deflection changes. We also have anger and aggression. So the response here is keep tone neutral, de-escalate after short breaks, offer short breaks if needed, and don't mirror hostility. Document threats, but don't use force. Guys, I've seen interviews and interrogations go wild where you have both parties yelling at each other. And to be honest with you, it's like they're jockeying for position. The investigator's best way to handle that is to remain calm, and their self-control gives them the control over others. But you cannot be going back and forth. You cannot yell back. You got to maintain control, because when someone looks at those videos and they see you yelling back, remember, you're also partnered. You also have a position of authority. So you yelling back and acting aggressive, connected to your position of authority, connected to your badge, can make it the perception of very intimidating. It can be very intimidating for the suspect or for the subject. So right off the bat, that does not look good, because it's not just you yelling at that individual. It's your position of authority. It's your badge. It's anything that can make that person feel inferior. So you have to be able to maintain calmness, stay cool, and worst comes to worst. Hey, why don't we all just take a break? We could revisit. So take about 10 minutes, breathe, but don't go nowhere, and then, take your little break. Then you have the more passive silence or withdrawn. You may ask a question, the person just locks up or looks away, and there's something there. You triggered something. And you may even give the person a chance to kind of sit on it a little bit, but you allow silence. Sometimes the pause encourages speech. After a measured silence, try a soft, open question. Hey, I know this is hard. Tell me what you remember next so we can move forward. We're going to come back. Remember, if I was the eye in the sky, if I was the backup officer that's watching you ask the questions, I may even say when we get through one round or one set of questions, I may say, hey, hold on, I'll be right back. Hey, can I talk to you for a second, Gan? Sure. Hey, listen, these questions he had issues with. You need to revisit these questions. The way he reacted, you may want to go back and have him clarify on these, because I saw a slight movement, or he answered this one a second less, where he was rapid fire with most. This one, he took a while to answer. This one, man, I don't know if you caught it, but when you asked that question, that soda, that drink, he put it right in front of you and him, as if there was something he was trying to block on the subconscious level. So that's why you need that extra person. Then you go back and then you revisit those areas where you felt they were more sensitive with. Again, maybe a timeline, maybe contact, etc. Then you got feigning confusion or memory loss. So the response, narrow the time frame, ask for corroborative anchors. So who saw you at noon? And present independent facts to test the claim. So you're going to see that a lot. People that may even say they're confused by the question. So you may have to ask it again, but you don't go over and skip it. You must stay on that path. So when they start feeling uncomfortable, that's a good reason for you to revisit. There are some times where people say, well, that question makes them uncomfortable. Well, that's more of a reason to explore it. But maybe we can look at another way to approach it, so we can at least get them to open up. And then when eventually go to apply pressure, then we could, do what we got to do at that point. But right now, I need him to answer questions in that specific area. So what will be the best way I can approach it to lessen the uncomfortability, if you will? So that's where minimization comes in, all that stuff. And then you got your pleading innocence and story changes. So how do you respond? You keep the facts in front of them, ask them to walk you step by step through the moment, and you can verify, pressing for consistent details. And that is definitely key. When you're trying to interview somebody, you got to hold them to those specifics. And again, you can't allow for them to answer in generalities. You can't really challenge generalities as much. You need the specifics, because evidence, the language they speak is specifics. That's what they speak, not generality. And generality just gives the person who did something wrong just too many ways they can run with. So important. You never threaten. You never promise leniency. You don't control or lie about evidence in a way that would make that statement unreliable or coercive. Now, you saw the caveat in that, right? You never lie about evidence in a way that would make the statement unreliable or coercive. That's important, because believe it or not, investigators do have the ability to lie if need, but you got to be very careful when utilizing that. Okay, so now this is where you, at the very beginning, remember I told you got to have your evidence in play. So I got the specifics. I mentioned this earlier. So we started with open questions. Now I'm drawn into the specifics. So I got all that in play. Now, and this may not all be done in one interview, guys. This could take time. This is not just one 8-hour sit down. I mean, this could be literally a back and forth. You release, but don't go nowhere. And a week later, they come back, and now you got more things in play because you're always gathering evidence. Now the evidence starts to speak to the investigator, and now I got to translate that language technically to some extent to the person that I feel could be the person that has an interest, that we have a person of interest. So the strategic evidence presentation, controlled and non-coercive. I'm going to keep on saying that. So what's the goal? You want to release plausible deniability by confronting the subject with verifiable facts in an order that tests their account. So the timeline is extremely important here, because the evidence is probably going to first work on the timeline and then work on other areas that the person was pretty confident with when he was open. Now, I'm going to work with the timeline. I'm going to work with, in this case here, contact with Celeste. And I got evidence here that hopefully will help me start creating the truth, the narrative that tells the story. Because again, you got his story, but then you got the truth. And the one thing you don't want is the investigator story. That's so you got either his story, which you're going to challenge, and then you got the truth. The investigator story, got to be very careful. So the investigator story really is led by the evidence, is led by the truth. And what they do is they piece together the information, and that becomes the story that they lean on. But that's still not the investigator story. That's the evidence. Because if it's the investigator story, that's bias, all this other stuff, will never last. That's the evidence. My job is I speak for the evidence as an investigator. So you want to present the verifiable facts, not speculation at this point. You really want to hit in the facts, because he gave me specifics. I'm going to kick you back and challenge those specifics a little bit. Start with less incendiary facts to see if the subject story changes, like a GPS ping, a receipt, and then you escalate. So you start small, and then you use soft confrontation. Hey, we pulled your phone GPS. It was near whatever location at 1522. Help me understand that. This forces explanation rather than an immediate denial that can be disproved. Because imagine if the person says something and I go right back out. Remember, I'm building a rapport in the process of this. I'm trying to at this point, I'm trying to maintain a rapport. Because trust me, if I can get him to admit to things without having to cross that crazy interrogation line, that's great. But you have to assume it could go that way. But I'm going to try to keep it as soft as I can for a bit. So, hey, I noticed you got a ping, or the GPS knows you were here, 1522. Can you tell me, does that make sense to you? Can you tell me if you were there at 1522, as opposed to saying maybe in the person's timeline, they don't mention that area. And then you quickly got the evidence and you want to have the I gotcha moment. You say, hi, you're lying because the GPS said this. Foolish. Now that person becomes resistant. There could be many reasons why the GPS says that. Guys, sometimes we look at something in the news and we only see the one reason, when if you've been in the investigative division, there's 20 reasons for many things. And the lawyers know every one of those reasons. So do people that have been trying to prepare their stories. So imagine having to break layer after layer after layer, lie after lie after lie, until finally you get the truth. Because the real thing is people will lie as much as you allow it. So you have to challenge it and make it an exhaustive effort. So they just get tired and mentally they're done. That's what winds up happening. You exhaust through the layers of lies until they can't do it anymore, and they just so mentally tired that they give up. And that's the truth, but that's a persistence that could take a long time. Some people are just experts. But again, it's a lot different. I'm sorry, the GPS said this. Can you explain why the GPS would say that? Again, I didn't challenge you directly. Just why is the GPS saying 322? As opposed to just, I got that moment, I got the evidence that said I'm coming for him. No, this ain't a win-loss here. Because technically, I know this may sound crazy, I need that person as best I can, their cooperation to solve this matter, even if they did it or not. I still need their cooperation. And if I could get it without, having to pressure it, that's great. That's phenomenal. That looks great in court. But if there's resistance, then at a certain point where I got enough, then I can start crossing into that challenge, then I will. But remember, when that happens, that rapport is gone. The cooperation on that side tends to be gone, tends to be more resistant. Now it's just more layers to build through. So soft confrontation, and it's not an oxymoron here. Soft confrontation is legitimately a great way to express what that next step is. So you avoid lying about evidence. In many jurisdictions, deceptive practices can render confessions inadmissible and are unethical. So even though you are able to lie to a certain extent, you got to be very careful. It's not something that if you're inexperienced, you don't just start doing that, because again, people could turn that into coercion, but it can be used if you need it to prompt something. So when I mentioned before about holding hands, it's more of a minimizing, because maybe they could have had sex. So I'm saying, hey, I saw some people saying that you were holding hands. And if the person wants to say, well, yeah, we held hands, but nothing more. Okay, just wondering. But if a lawyer says, hey, whoa, don't answer that. Who was the person that told you that? Hey, you know what? Don't even worry. Don't even worry. We'll move on to the next question. I'm not going to now build more lie after lie after lie when, I just, you know what? You're right. Let's get to the next question. Let's see. You want to keep the tone calm. Evidence presented angrily invites a shutdown or invites lawyers to shut it down. So the typical sequence here is you present a neutral timestamp or innocuous photo, let's say. Observe response. So you want to see if there's a correction, a pause, an admission, or a new story. Because now I got something here that maybe the first time I'm showing you it. And then you're looking at, oh, shut up, maybe I was here. That's me. And then you give them a chance to sit on it for a little bit. If denial persists and evidence is strong, you present corroborating sources, bank records, CCTV stills. So again, if I'm pushing it and you're like, I didn't do it. I know you're saying you didn't do it, but let me just show you something. Hey, can I get that picture there? Is this you? Is this you at the bank? Or is this you with Celeste at the concert? Is that Celeste? Would you say that's you? If the subject changes their story, document the contradiction and ask them to write or repeat their current position. So, guys, I want to mention something here, and I'm sure a lot of investigators are aware of this. When you interview a suspect, the more evidence you give to go ahead and conflict their specifics, remember, is the evidence that they're able to utilize to create their own narrative as well. So an expert liar now, you're giving them the information to create a better narrative. So you need to document 100% what was originally said on pressure, the open statement. So this way you can document the differences later on when they start to shift their story. Because that's the thing about interviews and interrogation, especially if you have a good lawyer, which I'm sure he'll have. And I don't know how smart David may be, but the more evidence I give you to conflict with your story, your open narrative, the more you can utilize that against me to create a new narrative. And then I have to be able to showcase that, hey, guys, look at these two different stories. Yeah, I know he said this after he was given the evidence. So he created his narrative by what I gave him, but look at the original statements. They don't match. So I need to make note that everything he said, he only said at this point after the evidence was presented to him. But in the open statement, when he was drawing from whatever he could, and I questioned him on specifics, he didn't say all that. He's only saying it now. That's because I introduced him some facts that he's having trouble challenging. So now his whole story has shifted. And guys, there's a difference between because when you interview a suspect, you have to note that, yeah, there could be questions that bring out new information, and sometimes people may have to update it, but that doesn't mean they're changing the integrity of it. So you have to understand as an investigator the difference between a statement that outright changes everything and violates the integrity of what was originally said, or just an update. Yeah, that was something he didn't think of in the moment, but that he wants to add now. Okay. It doesn't conflict with anything. It doesn't challenge anything. So I get it. You know, it was a good question that maybe wasn't thought of when we originally took his statement. Makes sense. But when you present something, now everything conflicts. Yeah, I get what you're saying, lawyer, but this really, if you look at what he said before the pressure and now you got the pressure, these are two different stories. These are two different stories. And it's tough, man, because when you introduce evidence, you're also letting the other side see how they want to work that evidence. So you have to make sure you're on point with that. And then the order presentation, it matters because it allows you to catch adaptive lies and see if they retrofit a story to match your claim, or they may contradict earlier statements. And that's why it's very important for that level of comfortability and no pressure during those opening statements. Because I'm going to lean on those opening statements. And if I feel those opening statements were pressured, and if I was the lawyer, I'm going to say none of that shit at the beginning matters. They were pressured to say all that. So of course he, you know, maybe now he said a different story, but I don't buy that opening statement. And guys, that opening statement matters because that's the unpressured story. That's what everybody builds from. They build from those opening statements. So I think another reason why there could be a delay here is because we just don't have enough evidence to create a good narrative to go after this person and probably a strong lawyer. So now phase 5, there's 8 phases. I should have said that at the beginning. Phase 5 is the cognitive interview and the memory facilitation. So the goal here is to elicit more reliable recall without leading the subject. Now think about how hard that is and how that gets twisted. Because as an interviewer and investigator, you're probably going to get a lot of people that are going to play forgetful. Or maybe they forgot. Maybe it was such a crazy moment that they just can't recall. And now you have to go into that mind and try to pull it out, which is dangerous in itself. Sometimes you may see people really forgot that they did it, and then the investigator prompts it out, and the person winds up becoming mentally disturbed to some level. Then you may have to say, hold the interview, hold on, let's get some help here. Let's see what's going on, because this person may have just realized that they committed something that they weren't fully aware of. They could have blacked out of the moment, truly forgot what they did, or just can't recall what they did. So you always got to make sure that when you're interviewing the person that you also take their well-being in your best interest. One, obviously, because they're human. I know a lot of people may not want to see that, but in this line of work, it matters. And 2, I need to have credibility with whatever gets pulled out. So if I don't take their well-being into interest, who knows where I'll go? Open a door to being unethical. You know, that's why we have to see the person as a person, and it's not a win-loss for us. I'm not chasing a win or loss. I'm chasing the truth. So there could be times I'm wrong, and that's okay. It is what it is. So this is the cognitive interview approach. Ask the subject to recall events from different perspectives. So e.g., for example, describe the moment from the viewpoint of the passenger seat and different temporal orders, reverse chronology. It's funny. People, when they memorize a script, because maybe they've worked with their lawyer and they memorize a script, and most investigators are aware that they're going to do this. They're going to have a script that's memorized. They may not be able to go off the script too far because sometimes the script only has a few layers. So you as an investigator have to peel back every layer until you get to a point where it's not so scripted. And sometimes it may even begin from telling them, hey, I get all this, but do me a favor, start from here. Or go backwards and tell me. Because they remember their script such a perfect way that they really can't give it any other way. And then you start to see the inconsistencies where someone is telling the truth. It doesn't matter what order you tell them to say it in, they lived it. You want to encourage sensory details. What did the place smell, sound, feel like? Sensory detail is harder to fabricate consistently because that's one thing liars forget to put in is how they felt. what the room smelled like. Believe it or not, guys, all this could also be used as evidence. You know, a bar has a certain smell to it, or, you know, the concerts. You know, you said you were at the concert with her, or I'm sorry, you said you were at a concert that you weren't, you know, with her. What did it sound like in there? Was it loud? What happened? Break big events into micro events. What happened at 1500, then 1505? Micro anchors increase chances of contradiction if lying. So when you create a timeline, and at the very beginning, it's your first establishment of a timeline. It's opened. Again, you're getting the narrative from him. The timeline probably at a pattern that they may not realize they're setting. It could be every hour. Who knows? Sometimes you also have to look at skips in timeline too. Like if this person is pretty much telling me something every hour on the hour, but for this section here, it looks like he jumped 2 hours. Something happened here in these 2 hours that the person's not comfortable with. So that's an area you're going to want to revisit. But then when you start pulling specifics and you start looking at the evidence, then you fill in all those gaps. So it goes from an hour to maybe every half an hour, to every 15 minutes, to pretty much every 5 minutes. I mean, you are literally going to get minute by minute. But one thing that good investigators do is they look at the timeline and they look at the original pattern that's set by that individual. And they look for any changes in the pattern during that timeline, any giant skips. So if they're giving you a timeline, as I said, hour by hour, and now this area skipped over 2, I'm not going to do it right away, but I'm going to go back and I'm going to visit those 2 hours, you know, so, and then eventually draw more specifics. And no, cognitive interviewing is non-coercive and improves recall accuracy. Number 6, ethical use of minimization and moral framing. So you still have to be careful with it. Again, minimization is not something you use freely, but trained investigators know how this works. Because if you don't minimize, then the person will strictly think about the consequences. So sometimes their resistance to answer has nothing with them wanting to admit it. It's just they're afraid of how they could be judged or perceived. So the goal is to provide a pathway for voluntary admission by reducing perceived stigma, but avoiding manipulating or promising outcomes. Sometimes you'll get people that are like, well, if I say this, this is how people are going to judge me. Well, I can't control how people are going to judge you, but we should start doing the right thing, and then we can cross that road later. So you want to provide, okay, wait. So what it is, okay, so it's in lawful interviewing. Sometimes an interviewer offers a way for the subject to tell the truth without being publicly shamed. For example, if you made a mistake, telling us now gives us the facts faster so we can understand what happened. I didn't promise you tell me now I'm going to get you a lighter sentence. I promised you that let's get the facts faster so we could figure it out before the public starts running on their own narrative. We don't want that, right? We don't want the public to, you know, figure out what they believe is the truth, figure out your why if you did do something, right? You want to be able to tell that story. So remember, my job at first really is, I'll deal with the excuses, the motive later. My job is to get you to admit, you know, or get that person to admit what they've done. And then everything else, we'll figure it out. But I need this person to admit that, and then we'll work on it. But, you know, if you start to get them to want to talk, which is hard work, it really is, then the obstacles around that could be their perceived consequences. So I know I got him. I know I can get this guy David to talk. I know I can. But I have to just remember, he's a public figure. I mean, most of the information about him right now is coming from the internet. The people that have been following his career, his biggest fans are now his worst enemies. So I have to find a way. I don't know about minimize, but I have to find a way to control that consequence to some extent. You know, we could deal with the fallout later, but wouldn't you want to start getting the facts out there a bit quicker before people start running with it and creating their own narrative? Because once that narrative sets in, they're never going to believe yours. So it's your call. How do you want to go about and do this? So how to do this ethically? Offer a neutral fact-focused option, not a promise. For example, if something happened that you didn't mean to explain, For example, if something happened that you didn't mean to, explain to me now. Getting the facts helps everyone. Don't say things like, if you tell me now, we can make a deal. That's an unauthorized promise. And use it only after evidence is strong and after you've given the subject a real chance to explain. Why you have to be careful here is this technique can be helpful in secure involuntary admissions, but crosses into coercion if paired with threats or illicit promises. And that gets tossed, will easily get tossed out in court. The defense will be all over that. So I don't think there's nothing wrong with me saying, hey, right now it feels like you want to tell me something. What's stopping you? Can you tell me what's stopping you? I'm in the public spotlight, Ganj, and this could ruin my career. And it could ruin your career right now with people just making their own narrative. This is your chance to do what's right, but it's also your chance to get the facts out there. Because right now, all they have is speculation. You're the one that knows the facts. Phase 7, 2 more phases left, is handling partial admissions and securing details. So goal is if subject begins to admit, like we're starting to talk now, convert vague statements to verifiable, recordable facts. It's funny how some people will run with a partial admission when it's really like a red herring, right? I'll say this, you'll run with this, and I got it. And you don't got shit. You got what I want you to get. I was willing to do that. Maybe I'm willing to admit I had inappropriate relationships with a minor, for David, and I'll let you run with that, but I'm not admitting to any involvement in her death. But it's a partial admission to the incident in general. Don't get me wrong, it's good to have that admission too, but I also want to know what happened with her death. And that's probably, to me, the stronger case. But the other thing does relate to it. It's foundational. So one opens the door to the other. Steps. When the subject says something like, it was an accident, and we talked about this, immediately ask for step-by-step details. Names, times, location, actions. Because remember, a person may not want to admit to murder, but they'll admit to an accident. It's less consequential. But it gets them there. Then we could always figure it out if it was an accident later. So now you have a new set of evidence you'll be building on. Get them to write or verbally state the steps slowly. Ask them to repeat it and sign. Initial, a short written account if legally permissible. They always got to have that written confession. They can say whatever they want, but it's the signed confession that matters. Verify consistency. Ask the same question later in the interview without warning to see if answers match. So again, you're getting the consistency. And then preserve evidence immediately. Secure phones, request consent for forensics, ensure statements are recorded with timestamps and chain of custody. Important legal note here. If the subject invokes attorney, pause and consult local policy about continuing questioning. Because now it's getting to the point where there's an admission. And sometimes they may call the lawyer not to second guess the admission, but maybe try to work out some type of deal. Like, okay, my client is willing to admit, but before we go forward, what are we looking at? And, what can we do to maybe make this a little bit more lenient? If he admits to this, it could be death penalty. Can we get that off? I mean, these are all like dialogues that, again, the investigator really has no say on, but they could push it upwards to see what people are willing to do. You may see that with the Emmanuel Harrow case, I think. Maybe. Closure, documentation, and next steps. So goal, end ethically, preserve the record, and prepare for legal follow-up. This is just the actions. Summarize back to the subject the key admissions and ask them to confirm accuracy. Ask if they want to add anything. Sometimes they volunteer clarifying details. That's good. Have them provide a signed written statement if allowed and voluntary. Document the entire session, timestamps, evidence shown, verbal written statements, refusal to answer, counsel, for them to invoke counsel if they wanted. Inform them about what happens next, custody, legal representation, further interviews per policy, and why this is good, because good documentation reduces later disputes about voluntariness and record completeness. I had some thoughts here too. I wrote on the side. If someone's resistant and they say, I don't remember, you can respond by saying, who can confirm where you were at 6 p.m.? Do you have a receipt, a text, a camera ping? Let's check those. So this is basically, I put some things if someone resists in a certain way. So if they say they can't remember, maybe you can pull for another witness. Will you have someone else that was with you at that time that can help you, or any receipts from that day? Or let me see your, what about your phone? Any pings? If they're, let's say they want to be silent, I have you pause for 20 to 60 seconds. Then if it's easier, tell me the last thing you remember before whatever X. Then if they're angry or mad, you could say, I'm not here to judge. I'm here to get the facts. If you prefer a break, we could take one to de-escalate. And then repeat. If they lie, you repeat the lie. If they keep on repeating the same lie, you present an independent fact that contradicts it and ask for reinterpretation. Hey, we have your phone ping here. How do you explain that? And it's a fact-driven challenge, not a moral condemnation. And that's the key, guys. People are going to lie. You should expect it. So sometimes when you challenge a lie, it's more about the integrity. So if you could say, hey, listen, I'm not here to judge, but you got to admit, man, you're saying this, but the evidence is pointing here. So again, I try to hopefully make a case for why it could take so long to charge somebody. There's a lot going on. In this case, it may be a little bit harder because he's got a good lawyer, I'm sure. And, that's always going to present an obstacle. And he's got a lot of reasons to be resistant. A lot of things coming at him. So, the investigators got to make sure everything's on tight. They're on point. And they have to peel back every layer. Hopefully you enjoy the content. Please share, guys. I'm trying to build up my subscriber count, but since there was no updates, I figured I would try to do some research on a lesson. And guys, nothing. I'm not going to stand by and say everything I put out there is perfect. I mean, someone that works this too may have a different perspective. But I do feel it's aligned with the knowledge that fits this case. Maybe knowledge that fits a lot of cases. But I'm always willing to learn. So if any investigators want to come on and tell me the process, message me. But that's why I want to build a bigger audience so I can get better guests, because the guests I've been asking for, they look at your subscriber count. That's one of the questions that they ask me. And then they say, well, they're busy. And then at the same time, they're going on someone else's show. So I know what I try to do is really powered by you guys. I answer all your questions. I respond back. So any help, again, I'm going to kind of make that plea for each episode, just so I can help build my audience, because I need your help. But as always, guys, I'm still going to produce content, and thank you for those who have been supportive. Love you guys. Stay safe.